So, the main source of what we're going over today is this copyright registration guidance. This is on works containing material generated by artificial intelligence. So, before we jump into this, which came out March 16th, 2023, so last year, it references something back from the report of the Register of Copyrights in 1965 in the footnotes, and I think this is kind of prescient for how long have they been dealing with these issues. As computer technology develops and becomes more sophisticated, difficult questions of authorship are emerging. The Copyright Office had previously received an application for registration of a musical composition created by computer. This year, copyright was claimed for an abstract drawing and for compilations of various kinds, which were at least partly the work of computers. This year, remember, 1965. It is certain that both the number of works approximately produced or written by computers and the problems of the Copyright Office in this area will increase. The crucial question appears to be whether the work is basically one of human authorship, with the computer being an assisting instrument, or whether the traditional elements of authorship and work were actually conceived and executed not by man, but by a machine. So, 1965, we can see that we've already got people in the Copyright Office thinking about generating things with computers. Essentially, generative artificial intelligence. They're already addressing this here. Back when it was, in most people's minds, the stuff of science fiction, right? So in this, it references a couple cases historically that go to this decision. Remember, the Copyright Office doesn't make the law; they're interpreting the Copyright Act as executing the Copyright Act as interpreted by the judicial branch. So we are going to be looking at some judicial decisions here. Getting down here to the crux of the matter of the human authorship requirement. Now remember, this is somewhat old news because this happened in March 2023. So we've seen this in execution a little bit, and one of the cases we're going to look at today actually came out after this, and it is kind of rebutting this in litigation. The complainant comes and says that their AI software can produce copyrightable works, or should be able to. So we'll get into that as well. Here is the Copyright Office on the human authorship requirement. In the office's view, it is well established that copyright can protect only material that is the product of human creativity. Most fundamentally, the term author, which is used in both the Constitution and the Copyright Act, excludes non-humans. The office's registration policies and regulations reflect statutory and judicial guidance on this issue. We are going to look at these court cases. Federal appellate courts have reached a similar conclusion as the Supreme Court above, which I just skipped, when interpreting the text of the Copyright Act, which provides copyright protection only for works of authorship. The Ninth Circuit has held that a book containing words authored by non-human spiritual beings can only qualify for copyright protection if there is human selection and arrangement of the revelations. In another case, it is held that a monkey cannot register a copyright in photos it captures with a camera because the Copyright Act refers to an author's children, widow, grandchildren, and widower, and these terms all imply humanity and necessarily exclude animals. Again, this is Copyright Office saying this.